All right, of course, relating to the evacuation of those South Africans. And we know that the South African government has said it's at an advanced stage at the moment of getting them from Wuhan city to South Africa. We're not sure at this stage when they will be brought back home. But of course, the latest statement coming from government communications indicating that an aircraft has been secured to evacuate them and a transport plan is being put in place to bring them to a central collection point on arrival. On arrival, they'll be placed under 21-day precautionary quarantine at a venue yet to be secured. Advocate Michael Osborne joins me now from our Cape Town studios to talk about what the law says about involuntary isolation. A very good evening to you, Advocate. Thanks indeed for joining us here on The Full View.
Good evening to you, Griselda.
Great. Advocate, so these citizens from Wuhan will go into quarantine. What does the law say specifically about involuntary isolation?
Well, the law makes provision for involuntary isolation. There's regulations which were issued by the Minister of Health back in 1987, which do provide specifically for quarantine in the case of persons who are or are suspected to have been exposed to communicable diseases. Express provision is set up, and one can expect that it's these regulations that will be invoked for purposes of the 21-day quarantine to which you referred.
Yes, that 21 days, of course, is what the health department has described. Well, the incubation period, of course, being 14 days, and the rest of that as just a precautionary measure to just make 100% sure that they've not contracted the virus. Does the regulation or the rules themselves state anything about the time frame or how long you can keep them in isolation?
No, it does not. And it would appear that the regulations have been phrased in a somewhat open-ended manner, precisely so that health authorities can be granted the necessary flexibility to deal with different kinds of communicable diseases. Mm-hmm. So one would expect that the regulations will be interpreted in such a manner that they can satisfy their purpose of protecting public health, and that to the extent that any objection is raised to the terms of the quarantine, I suppose a court would have to make that determination. And it is regarded as constitutionally problematic that anyone be detained without their consent. It's rather unusual in a constitutional democracy. The most perhaps comparable or analogous situation is detention under the Mental Health Care Act.
Yeah.
And in that case, very stringent protections are set up for those who are involuntarily detained. You need to get a court order with the advice of two physicians. In the case of the quarantine provisions we're talking about, by comparison, yeah, there's no specific reference made to a court order being necessary.
Yeah. I mean, an instance where, for example, Advocate Osborne, where you have someone who does not want to go into involuntary isolation, what happens in an instance like that? Could someone challenge a government wanting to take those kinds of precautions? Is that possible?
Yes, indeed, it would be possible. Although no express provision is made under the regulations, it's always going to be possible under Section 12 of the Constitution for anyone to challenge their isolation or their detention, which is not voluntary. But they'd have to show good reason. In the sense of showing that perhaps it's irrational, it's disproportionate, that there's some measure of discrimination. And one could imagine a situation where if one particular group of persons who'd been exposed or had potentially been exposed were not held in quarantine and another group was, you can imagine a person raising the objection that this is an irrational, arbitrary detention, and one might well expect a court to hear such arguments sympathetically. But essentially, it's a classic balancing act between, on the one hand, the imperatives of public health in the face of a very substantial health concern, and that has to be to be weighed against the right not to be detained without the benefit of judicial process.
What would the constitutional right then be of those 184 who want to be evacuated from Wuhan city, in particular because after that 21 days, according to a press briefing that the health department had on Sunday, they would then be released into the care of their loved ones. Should it be found that perhaps there needs to be more tests that need to be done, because we don't quite understand fully the coronavirus at this stage. I don't think anybody can understand it quite fully. Would the South African government be able to go back and do those kinds of tests if they feel uncomfortable about certain cases, just in terms of the law?
Well, yes, the answer must be in the affirmative. In fact, as I understand it from what the Minister has stated, is that there will be periodic screenings taking place within that 21-day period. And if, for example, someone tests positive, say on the 15th day of that initial 21-day period, that clock could start ticking again, and you might then have a further 21-day period. So it's indeed the kind of thing that could be significantly extended, dependent upon the periodic screenings that will be done within that initial 21 days. Now, if someone is unhappy or says that the extension is unreasonable, once again, they will have a right to approach a court of law on an urgent basis and demand that the government provide reasonable, non-arbitrary, objectively verified medical evidence, which would justify the rather extreme measure of taking away someone's freedom.
Would there be any recourse for a family, for example? The latest statement from government communications, which dropped just a couple of moments ago, indicates that there are still some South Africans who do not want to return to the country. So obviously, them being at the epicenter of the outbreak of this virus, if indeed something happens there, nobody knows what's going to happen, but if something happens and perhaps a family here in South Africa feels that maybe their loved ones should have been coerced even more into coming back for their own safety, would you really find a situation like that?
Well, if you're talking about people who've not requested to be returned but wish to remain in the People's Republic of China, these are the kind of people who, under the law, can demand that the South African government extend its protection to them. So that, for example, if they felt they were being unfairly treated or indeed being unjustifiably held in quarantine by the Beijing government, yes, they would have the scope to approach a South African court requiring DIRCO to make appropriate representations to the Chinese government.
All right, thank you very much indeed for joining us tonight. A great insight on the whole isolation process and, of course, the evacuation of those now 184 South Africans. That number gone up from 151, the latest statement dropping from government communications indicating 184 South Africans in Wuhan city, the epicenter of the coronavirus, now wishing to come back home. Advocate